You really need to be aware that not responding to those at all can get you in some forms of trouble, depending on the request. Self-help, the ability to enter into someone's unit, whether they're there or not, with reasonable notice, et cetera, is something most attorneys will advise you against doing nearly 100% of the time. Because if someone says something broke, something is missing, money was stolen, et cetera, you've sort of created a new cause of action out of whole cloth, right? They can sue you for something made up. And unless you were really careful about multiple people and videotaping your entry, et cetera, it's very difficult to prove the negative. So we don't typically recommend you use self-help provisions. So there's two remedies left if you don't use self-help. The first one is the finding process, and I always recommend you use it. And then the last option of enforcement, which is your only other option of enforcement, is to petition the courts. In this case, it's a form of injunction. The downstairs neighbor has a cause of action against the upstairs neighbor. There may or may not be some things in your documents. There's typically not that'll force the association to get involved in that dispute. But if at all possible, you want to stay out of it. When you make decisions as a board member, you are protected personally by something called the business judgment rule. Business judgment rule is important as long as you take actions that are your goal whenever there's a dispute between homeowners is to absolutely stay out of it to the maximum extent possible. Now, once you have become a party to litigation and you've inherited that, there's an additional elephant in the room in the form of legal fees. If you drop your case and you think you have any chance of winning, at that point, the other side can petition the court for legal fees. And that might be a lot more than the initial dispute was ever about. That's pretty common. Again, fees driving the bus. So there's an analysis to be done. What